Welcome, everyone. This is Karen Applegren with the Zions Bank Business Resource Center, and we're excited that you've joined us today for the first in a series called the Legal 411 Operating a Business. Today we'll be focusing on business basics, and we have some great presenters from Holland & Hart. We're really excited to partner with them to bring their subject matter expertise. Legal is such an important piece of operating a business. We want to remind you that there are two other sessions this month. Next Wednesday, August 12th, at the same time, 11 to 12, Holland & Hart attorneys will be presenting on the topic of cybersecurity. Again, on Wednesday, August 19th, from 11 to 12, Holland & Hart attorneys will present on employment law. All of these sessions are complimentary, and this is only a small piece of what the Zions Bank Business Resource Center provides to the business community. We offer other workshops. If you visit our calendar, zionsbank.com/BRC workshops, you'll see other events happening, such as our LinkedIn Strategies class tomorrow from 11 to 1. And we also offer complimentary one-on-one business counseling. So whether you bank with Zions or not, you can make an appointment to talk about getting help with business plans, financial projections, or learning more about financing options. So without further ado, because we have a lot of content to cover today, I'd like to introduce you to the attorneys who are presenting from Holland & Hart, Lauren Prue-Fauser and Craig DeMeyer, and I'll let them take it away.
Thanks, Karen. We're excited to be partnering with Zions for this presentation today. Like Karen mentioned, we're going to dive into a bunch of content regarding kind of your legal basics for starting an entity and why you might be thinking about some legal issues that are coming up early on in the company's history. We'll cover a lot of different topics and just kind of glance over those issues that are at the forefront of pretty much every startup's kind of legal questions that might be coming up. And if you have additional questions, please feel free to, of course, reach out to Craig or myself. There's also a Q&A option where you can submit questions using the sidebar. We're going to ask that nobody ask verbal questions just so we can respond to them at the end of the presentation, and we'll leave about 10 or so minutes to make sure that we're addressing those. And then once we've had an opportunity to go through our slides, we'll kind of hit any of the questions that you all might have. Craig and I are both corporate attorneys over at Holland & Hart, as Karen mentioned, and we work with companies of all different sizes. We work with folks who are just starting and setting up a business to more mature companies that are looking to, sell or acquire other companies. So our space definitely runs the gamut of everything from single member entities to entities with tons of shareholders. And we love working with companies of all different shapes and sizes. So hopefully today you can find at least a couple points to take away and maybe think about applying to the business that you're running or the operations that you hope to pursue in the future. And like I said, if you have any questions, don't hesitate to reach out to either of us and Karen, of course, at the Zions Center as well, and we'll be sure to address those questions and get you the resources that you need. So Craig is going to start us off with kind of an outline of the topics today, and then we'll dive into content as we go. So thanks all for attending. Craig, do you want to take it from here?
Yep, I'm on board, Lauren. Thank you very much. So we are going to start as we hop on. This is a brief outline, like Lauren said. So we're going to kind of slowly work our way through these main topics. First, just discussing what types of entities are available to you as business owners or prospective business owners, and we'll identify a couple of key characteristics. And hopefully you'll be able to, quickly and easily put yourself in one camp or the other, depending on what business you're running or hoping to run. We'll also just briefly discuss forming an entity, just a couple of, relatively easy steps to form an entity, and then there are some background stuff which will help kind of tighten your control and better understand what business you're running. We'll cover the legal documents that are required or at least highly advised. relating to forming and operating a business. And then, as Lauren said, we will discuss just some pitfalls and what are some kind of tips and tricks to avoid them. So the main question, or at least the first question on our slide, is do you need an entity? I will presumptively answer for most of us and say the answer is yes. And here are some reasons why you might need an entity. So if you have recently or already have initiated business operations, okay, you're running a business, asset protection is extremely valuable, and entities, one of the primary value adds is protecting either your personal assets or the business's assets. You can kind of segment things and provide some liability protection. If you're in the interest of raising capital, often those folks who are looking to inject capital in the marketplace or invest in specific businesses have a certain expectation of the types of businesses they're investing in, and that usually relates to a type of entity chosen, or they prefer to see something like a little more quote unquote mature or maybe more sophisticated businesses and entities. Succession planning is a not always fun topic, but it is a necessary topic in the personal context, obviously, but also specifically within the business context, to make sure that the hard work you're all putting in now can continue to grow for generations, and your ideas can continue to rise. If you are in the situation of where you're hiring employees or engaging in contractors, having an entity is really valuable in terms of making sure everyone's on the same page of who the actual employer is, and making sure that everyone understands what's going on and what everyone's roles are. And then I had spoken to this prior in terms of the initiation of business operations, little dot up at the top, but forming an entity is an opportunity to clearly define a prior handshake deal. In today's world, a lot of people come up with a lot of great ideas, and they'll get so excited they'll just dive right in and start just immediately running a business. And that's good to capitalize on that excitement and really try and get to market quickly and just kind of take advantage of having a great idea. However, there are some necessary questions that need to be answered, and especially if you form business with other business partners, the sooner you handle those questions, the more certainty everyone can operate under, and hopefully you will head off some I will say not fun conversations down the road. So that kind of forming the entity and setting up some of the corporate documents is a real way to get everyone on the same page and minimize potential roadblocks down the future. And as I said earlier, if you want your business to quote unquote take the next step, you're able to present yourself as a more mature or established company when, let's say, potential investors are, come calling, you're able to offer, sincere and consistent corporate records and things like that. So forming and efficiently running, or rather operating an entity, can provide a lot of value way down the line, even if you don't foresee that opportunity coming up. So we usually counsel our clients or prospective clients to maintain an accurate corporate record book, just in the off chance that the most amazing opportunity in the world comes out, you're ready for it, as opposed to you're going to spend a whole bunch of time and money in the last 15 minutes and be in a much more stressful situation than you needed to be. So that is covering some of the situations in which forming and operating entity would provide value to you as business owners. Let's just briefly discuss the types of entities that are available. So the key here is, as you can see, kind of the three, I would say, tiers or pillars of entities. The middle tier, both of which begin with limited, and the far right tier, which has corporations at the top, those provide limited liability protection. And as we quickly jump back to slide 5, as you can see, asset protection is one of the primary value adds that an entity can provide to you as business owners. The entities in the middle and on the far right will provide that asset protection. The entities on the far left are technically unformed entities, as in they are not formal entities, aka you didn't file the required documents with the state you're operating in. However, those entities will still exist, and but you won't have the liability protection offered in, say, a limited partnership, limited liability company, or a C corp or an S corp. So as I had mentioned earlier, some folks come up with an idea, let's say with one more business partner, and they get really excited and they run straight to market, and they're already running the race. They would have technically formed a general partnership, and although it is unformed, both of the partners involved are liable for anything the business does, and they are liable to and they are personally liable, which is another thing which is you know, a bit scary in my mind. So all of their personal assets would be quote unquote on the hook. A sole proprietorship is in a similar vein, but let's just say hypothetically I had an idea and went straight to market and was running the entire company by myself. I would be operating a sole proprietorship despite the fact that I had never actually formed the company in, let's say, Idaho. And so personally, my assets would be, I would be liable to the personal extent for the operations of my sole proprietorship. So those are kind of default entities, the ones on the far left, the general partnership and sole proprietorship, which if you don't do anything and you just operate a business, then you automatically fall into one of those categories, and those are not categories you want to be in. Moving to the center column, limited partnerships and limited liability companies, so LPs and LLCs. LPs are a little more rare. They're commonly seen, or at least we commonly see them in terms of investment companies like venture capital firms and things like that. They're routinely, those types of businesses routinely utilize the limited partnership entity. In contrast, the LLC is much more common, and that's for a number of different reasons. So first off, it allows you to choose, an LLC allows the owners to choose how the LLC will be taxed. So either it will be taxed as a separate taxable entity, or the taxes will quote unquote flow through the LLC and hit the owners. And depending on where you are and what type of business you want to run, either option can be a viable option. The second reason, and there are quite a few reasons why LLCs are incredibly common, is that the default rules for LLCs can be contracted around pretty aggressively. And what I mean is that there is an LLC act provided by the Idaho State Legislature, and it basically sets a bar where at a minimum, LLCs can't do X, can't do Y, can do Z. However, if you form an LLC and you prepare one of the operating agreements, you can basically kind of tailor fit how you want to run your LLC to your specific business and your specific ownership group. And so LLCs provide a lot of versatility, and you can really tailor things directly to who you are, how you want to run, and where you want your business to go. So LLCs, much more common, very versatile entities, and they also provide that added advantage of you can choose what type of tax regime you operate under. LPs, much more rare, although there are situations in which they would be the right entity for the right business group. So I wouldn't write them off completely, but the LLC is much more common. Moving to the far right, under the corporations tab, the most common here is the C Corp, and it is characterized by being a separate taxable entity. So, for example, when taxes are levered onto a C Corp, the C Corp itself will be taxed, and then any funds that flow from the C Corp to its shareholders, they would be taxed at that level as well. So there's a double taxation rate, which is unfortunate. There are ways to kind of work around that, things like that. The C Corp is much more common. It can provide a lot of value in terms of raising capital. As I mentioned earlier, quite a few investment groups prefer to invest in quote unquote mature companies, sophisticated companies, and having an entity be a C Corp kind of presents that, especially if you're able to back it up with sincere corporate governance, things like that. Also, if you're hoping to take your company public, usually having it a C Corp is the most efficient way to go public. S Corps, very similar to C Corps, however, they are much more regulated in terms of their ability to raise capital, also in terms of their ownership. So it has to have less than 100 owners. They all have to be American citizens, I believe. Lauren, if I'm incorrect there, please feel free to correct me. And there are some more regulations surrounding S Corp. So in the right situation, choosing an S Corp over a C Corp can provide a lot of value to you as business owners. However, the C Corp, similar to the LLC, is much more common an entity choice for the majority of businesses. Public benefit corporations are, simply put, a corporation where in their charter or in their formation documents, they state that they will donate a certain amount of time and money and focus the purpose of the corporation towards some sort of public benefit. Could be climate change, conservation efforts, things like that. But it is those efforts are connected to the corporation, and that is where a lot of, if not all of its focus goes. So depending on what type of business you're running or depending on what your goals are, that could be the right vehicle for you. And then lastly, there's the nonprofit corporation, which can make a lot of profits. However, all the profits are reinvested in the corporation, and they have a tax-free status, at least if you qualify under the 501c3 for the IRS. So depending on what your goals are, that could be the right motive, or that could be the right entity choice as well. So there are quite a few options, as you can see, available. As a kind of a high-level summary, I would do your absolute best to avoid the entities on the left. And depending on how you're hoping to get, and in the entity in the middle, the LLC is much more common. Entities on the right, the C Corp is much more common. However, depending on who you are, what you want to do, and what you're hoping to accomplish, the other entity choices are potentially the right choice for you. Lauren, do you have any other points to add or anything you think I may have missed out on?
No, that's great. Thanks, Craig.
Okay, perfect. So now we're just going to briefly discuss the formation basics of actually forming the entity we discussed earlier. Obviously, we're going to be avoiding the ones on the left pillar. So we're talking, limited partnerships, limited liability companies, corporations. So kind of as a rule, there's two sets of documents for those entities. First off, you have the external facing document, which is what everyone can see, going through the state where it's formed, that state secretary of state website. And then there's the internal document, which usually you can't see, and that's kind of a manual on how to operate the company. For the formation bit, just for this topic, this is all going to be about the external facing documents. So for example, if you're hoping to start a business in Idaho, you would just click on that link at the bottom, or you would simply Google, forming a C Corp in Idaho, and you would find a way to file your documents online. The primary question, as you can see by that second little bullet, is you need to determine the right state in which you want to form your entity. As a rule, you usually look at either Delaware or you look at the state in which your primary place of business is going to operate. For most of us, being in Idaho, that will be Idaho. However, there is a chance where maybe Wyoming is the state that let's say you manufacture all your products, things like that, so you would just sub out Idaho or Wyoming. Now, Delaware has inserted itself in this conversation because they have a lot of business and corporate-friendly laws on their books, and also their judiciary system has a long and well-established list of case law relating to corporations and business issues. So way back when, a couple of kind of forward-thinking Delaware legislators kind of built their state in a way that was very conducive to entities being formed there, and just by virtue of that, more entities were formed. When lawsuits were filed, they would be filed in Delaware state courts and things like that, and that kind of just grew and grew and grew. So now, basically, when you're looking to form your business, the rule, although not always, is you'll either form in Delaware or you'll form in the state in which you have your primary place of business. For most of us, that's going to be Idaho, so it's just kind of one or the other. Also, this won't shock most of our audience, but all 50 states do not agree on how they should title this formation document. So as you can see, Delaware calls them a certificate of incorporation. Idaho is articles of incorporation. Others call them certificate of formation, corporate charter, things like that. It's kind of all over the place. Primarily means the same thing. I will just briefly go over an example. As I said, these are external facing documents, and they're usually really sparse because anything that requires a lot of substance or anything like that, you can just place in the internal facing document. If it's a corporation, those are the bylaws, or if it's an LLC, that will be the operating agreement or the company agreement. And as I said, any of that stuff is kind of should be placed in the quote unquote manual on how to run the company. So for example, an Idaho articles of incorporation will list, there's only about 6 or 7 articles. The first one lists the name of the corporation. The second one lists the amount of stock that has been authorized. The third article will cover the registered agent, and that's necessary in the external facing document in case for lawsuits or for other reasons you need to contact the corporation. You can go through their registered agent. In this set of articles, they have a specific article relating to how the shareholders vote. That is not required. Article 5 covers a limitation on liability. Article 6 covers indemnification, and that's about it. So this example set of articles that I looked at was about a page and a half. And as I said, they're routinely very sparse. And most things are if they can be, will be placed in the bylaws of a corporation or the company or operating agreement of an LLC, and that way that stuff kind of stays in-house, so to speak. Oh, and then also forgot to mention just really quickly. So you form in let's say you form your company in the state of Idaho, and that's because Delaware wasn't the right choice or whatever, and you want to do a substantial amount of business, let's say in Oregon. So you form in Idaho, but let's say you have a major manufacturing plant in Oregon. As part of that process, you need to quote unquote have a foreign qualification in Oregon, and that's a very similar process to filing for the articles of incorporation, but it's simply saying your company, which is formed in Idaho, does more than kind of haphazard or random business Oregon, but there will be kind of a consistent flow of business, and therefore you would apply for foreign qualification, which is pretty easy to get, and you just need to maintain that so long as you're doing business in and with the state of Oregon. So keep that in mind. If you're just forming your business and it's just going to be in one state and you're going to be very local, you probably don't need to worry about that. But if you plan on shipping products across multiple states, or you plan on opening different subsidiaries in different states, I would just keep it in mind that you will likely need to apply for and receive foreign qualifications in those states as well. So the paper trail can grow pretty drastically depending on how successful you are, which would be a good problem to have. Finally, let's just briefly discuss the legal documents for formation. as I discussed earlier, right, the top document on each of these tabs, articles for corporations or certificate of formation for LLC, those are those external facing documents. And that's so kind of everybody can see at a high level how those businesses run and understand the key characteristics. The next tier down, the bylaws and the operating agreement for the corporations and LLC respectively. Like I said, that's kind of a roadmap or a manual on how to operate the company. Those are usually very lengthy, or they can be depending on how regulated you want the ownership of your company to be. They also can be, 9 pages in a Word document, depending on how much you want to just leave up in the air. So it all kind of falls on how you hope to run your business and things like that. And then there is this final tab. So there's you're taking minutes at meetings and things like that, or there's consents required if the business is taking action that is of a substantial nature. So on the left, you've got board of directors, which is the primary management group for a corporation. And those are elected by the stockholders, and the stockholders ultimately own the company. So if the stockholders will own, 100% of the stock, they'll elect the board of directors, and the board of directors will actually manage the company with the stockholders, hopefully keeping an eye on the board of directors and providing governance at a high level. Under the LLCs, you can choose to be either member managed or manager managed. If it's manager managed LLC, the members, similar to the stockholders, will elect that manager and then just provide governance over that manager. So it is a way to delegate the responsibility of operating the business. And a lot of that just falls on who the primary business person or business people are and how involved they want to be, things like that. So there is just a lot of variables. In terms of one quick thing just to briefly touch on, LLCs require a lot less of action and documentation just to maintain the company. And I'm going to just briefly discuss corporations as a way to illustrate this point. So corporations every year have to file an annual report with the state in which they're formed. So for Idaho, you would file an annual report on the Idaho Secretary of State website. You also have to have an annual meeting of the stockholders in which they can confirm the officers and board of directors for the following year, things like that. And LLCs don't need to do that. They can, if they wish to, maintain diligent corporate records. And I would advise that as you operate your businesses, if your business is either a corporation or a LLC or anything mentioned above, if you're reviewing, let's say, allowing another investor in or taking a substantial action, I would highly advise that you document that somehow, so it can just be in a consent. So for example, the board of directors briefly discussed creating a manufacturing facility in Oregon. They discussed, all possible alternatives and the pros and cons, and the board believes that this is the right action for the corporation. The board approves of this proposal. That is a way to show that the board is taking, the necessary thought and care required to ensure that the corporation is taking the right actions. So things like that, that type of stuff, at least the annual report and annual meeting are required of corporations. LLCs don't necessarily have that requirement. However, I would that you document those types of, substantial discussions or things like that. I think that's about all it for this first initial introductory period. Lauren, is there anything you would like to briefly discuss regarding corporations or LLCs?
No, I think I'll cover it in the next couple of slides, Greg. Thanks.
Oh, perfect. Sounds good. All right. So let's cruise right ahead to the next slide.
All right. So Craig did a great job providing an introduction as to what the structure of a lot of entities will look like and why you might want to think about having an entity. And as you said, general recommendation is if you want to protect yourself, if you want to protect the business partners you might be working with, oftentimes that's what really leads to the decision of, yes, we need to incorporate. Yes, we need to. So having a business entity, there are a bunch of tasks with that because it requires treating the entity as a separate entity beyond yourself, right? You're no longer using your own personal bank account. You're using a bank account for the entity because the entity is the being doing business, not yourself. So part of the list of startup tasks that we want to talk about just today and keep in the forefront of your mind as you begin your business, first and foremost is getting an EIN. So a lot of you have probably seen an EIN or maybe applied for an EIN before if you've run a business before. But it's an employer identification number. It's super easy to grab from the IRS's website, and it is basically the Social Security number of a business. It's what you use to file taxes. It's how you have a record with the IRS. And it's important because it gives you a registration number that you can use associated with any of your business filings. Oftentimes, you'll be required to submit an EIN when you do Secretary of State filings. You certainly have to submit it with your taxes. And then anytime you're registering for state regulatory filings, there are often requirements that you submit your EIN on that as well. So think of it like your Social Security number. For yourself, you want to protect that number and make sure that you have it early on. And it's usually required to do a lot of different types of business filings. This is something that your attorneys or your accountants can help you apply for. But it's also something that's really easy to grab yourself. So if you're looking to kind of maintain an economic way of registering your business, I encourage you to apply for an EIN on your own. Second tier of decision making after you've applied for that EIN is your tax selection. And I'm going to focus here on corporations for most of this presentation, but I will make a note here about LLCs, right? You can elect to be taxed as a corporation or a partnership as an LLC. It's one of the advantages of having this entity, but you need to make that tax selection sooner than later. And so working with an accountant becomes really important. Same thing with a corporation. If you're deciding between an S Corp and a C Corp, you want to have good advice early on about whether or not it makes sense to make that election. There are always ways to transition entities, meaning you may convert from an LLC to a corporation later on, so nothing is set in stone. But making smart accounting decisions and working with a tax advisor early on is something that's so helpful because it means you're saving costs in the long run, right? It's all about being efficient as you start and thinking more forward-looking, not thinking about being reactionary to the situation that you're in at the time, but thinking, okay, if I make this tax selection now, how does this implicate me in the next year? So making a tax selection is very important. Oftentimes you need to register for sales tax numbers. Those are usually associated with certain states. And so a lot of our clients are in the tech space and are working with an analysis on sales and use taxes. And so they need to do an analysis of where they need to be paying taxes on an annual basis and on a state-specific basis. So this is another area where it's really important to get good advice early on so you're making the right elections in those specific states to pay taxes and registering appropriately with each state taxing authority. Because if you aren't doing that right away, over years, you can, find out that you've been delinquent in paying taxes, not knowing that you were instructed to pay taxes in those particular states because of whatever product you're selling or whatever services you're providing. And as a result, can be subject to fines and penalties associated with the state. And getting good tax advice on those particular issues and having your registrations appropriately filed in each state can be really helpful early on because it'll save you money in the long run. Next item is making sure that when you are setting up an entity that you've got a really good idea about the ownership structure. And I want to talk a little bit about the two different types of ownership structures. So with LLCs, you've got members, as Craig mentioned, and those ownership structures can be set up as percentages, so member interest on a percentage basis. The whole company is 100% membership interest, and how many members hold what percentage, right? Or they can be set up as units. And units are the equivalent of shares in an LLC, and they're a nice way to delineate between sections of ownership, right, as opposed to thinking in percentages. So a lot of times it makes sense to start with units if you anticipate growing significantly, because that number will always stay the same. The percentages will automatically fluctuate without requiring adjustments. If you set those as percentage interest, then you're always kind of balancing the scale to make sure that you add up to 100. For corporations, like I mentioned, you have shares, and so you want to get those initial share issuances done early on, because it's important to establish that the company has an early history and that those shares have been purchased for whatever the fair market value is at the time of issuance. And as you can imagine, the more mature a company is, the more expensive those shares will become. And so the sooner you can get those share issuances done for founders, the better. You're going to save yourself money in the long run. And it also provides you an opportunity to make sure you've established what the ownership of the company is sooner than later. Last item here, just on initial startup tasks, is filing for a foreign qualification if you're planning to act in other states. And the reason that this is important is because if you are holding yourself out as doing business in other states, so if I am a business that has leased office space and has employees in Idaho, but I've chosen to form a Delaware corporation because I anticipate being a venture-backed startup, I have to register in Idaho as a business because I need to show the state of Idaho that I have foreign qualified there. I'm holding myself out as doing business in Idaho. I have a duty to let the state of Idaho know that I will be operating there. And so anytime you are leasing space, you have a significant number of employees as opposed to contractors, you need to start going through the analysis of whether or not it makes sense to pay an annual fee to that state, and if you're required to register there in order to do business in that state. And this is one where it's a kind of a combination of both legal and accounting advice. And it can get a little tricky if you start seeing your operations expand beyond your home state. So it's one where you want to get good advice early on, and as opposed to having a fine from some state authority that says, hey, you haven't registered to do business here, and yet you've been leasing a huge building and employing tons of people here. You know, that's a problem for us. We need you to be a registered entity and paying your annual registration fees, because the states want to track the business that's coming in and out of their state. So moving on beyond the initial startup tasks, there are a slew of other legal documents that are important to kind of keep an eye on as you grow and as you become a more sophisticated business venture. So right at the top of the list is one that I get asked about a lot from startups. So, hey, you know, I want to issue stock options to employees, or I want to talk about issuing profits interest units if I'm an LLC to employees. I want to provide incentives for these employees or service providers to stick with the company. How do I do that? And the first item is setting up an equity incentive plan or a profit interest unit plan, and issuing awards to the employees or service providers in a way that provides them with incentives to continue working with the company. And it's a great alternative to offering additional cash compensation, right? A lot of folks are tight-strapped businesses early on, and so they think stock options are a great way to incentivize employees to build a more valuable company. And I can get into a lot of the nitty-gritty details here, but it's something that you have to have in place before you issue equity to service providers or employees as a form of equity or incentive compensation. The next item is an advisory board. An advisory board is not your board of directors, not that governing body that focuses on the management of the entity of a corporation. It's actually a more informal board that has some parameters set around it, and they're oftentimes industry specialists who are providing specific advice to companies and helping advise kind of on important relationships that may be helpful to establish. An advisory board is a great way to have an informal relationship with somebody that maybe has a service incentive associated with it. So we often have advisory boards set up for corporations, and they'll offer stock options to those folks because they're service providers. And it's just a nice way to have a formal relationship with somebody that's less formal than the board of directors. The next item is probably the most common document that we help startups with early on, and that's coming up with a great form of employment agreement or offer letter. And offer letters are more common in the world that we kind of work in. They outline the description of the job, the compensation being offered, and any equity incentive awards, and also set out some parameters of, hey, these are the things you must do in order to be employed with us. So that's one area that I think is really useful to get some advice on early on, because you can use that as a template. Along that same line is a consulting agreement, and having a good consulting agreement, it can be helpful whenever you're thinking about engaging a third party to provide consulting advice to the company, but maybe is not necessarily going to be an employee. Non-disclosure agreements are also pretty common, and we have kind of mutual non-disclosure agreements that companies will often enter into. And we also have unilateral non-disclosure agreements that you may use with somebody who's just learning about the business and thinking about pursuing a business opportunity. Raising capital is an area that I've saved a couple of slides for at the end, but there are a lot of documents involved with fundraising. So it's important to know that you can't just go out and accept funds from folks and call them owners or members or shareholders. You have to have it properly documented so that you can show, basically have a paper trail showing how that ownership started. IP protections are another hugely important area, because most companies' value is often tied up in some of the intangible assets like patents or trademarks or copyrights. And making sure those items are actually legally protected is key, and that anything created for the company on behalf of employees or consultants is protected can be really, really important as well. And then this last item falls into the IP protection category, and it's called a form of confidential information and invention assignment agreement. And it's a mouthful, but it's attached to the offer letter. And it's basically a document that says, hey, you're going to be an employee or you're going to be a consultant. As a result of that, we want all of the work that you're doing to be owned by the company. And it's standard, right? If you're employing them and they're providing services on your behalf as an entity, you have the right to own that intellectual property that is developed in their work capacity. So that document needs to be signed before somebody starts as an employee or as a consultant. And it's important because it really protects the ownership of the intellectual property of the company and ensures that any developments by that individual will be assigned to the company going forward. Next up, I want to start going into legal pitfalls and give you kind of the basic pitfalls that we see come up on a routine basis. A lot of these legal pitfalls are really about thinking on a forward-looking basis, thinking about prevention as opposed to addressing problems as they arise. And that expression, hindsight's 20/20, a lot of times we can set individuals and entities up for success just by forecasting a little bit. Do you anticipate having, other business partners involved? If so, let's get an agreement on the table now as opposed to trying to negotiate later on. So that's my first legal pitfall, is really working with partners and how you get a written agreement in place before you actually come to a problem where the agreement has to govern. So our general advice to folks who are thinking about working with business partners or other owners of the company, whether that's an LLC or a partnership or whatever type of entity it might be, is to ensure that you've negotiated this document, this governing document that says, hey, here are the disputes that are going to arise. Here's how we'd like to handle them when you're on good terms, right? It's always easier to come to an agreement when you're on good terms with somebody as opposed to later in the trajectory of the company when things have already gone south. Trying to come up with an agreement with a business partner that you no longer want to be associated with is difficult. So establish that governing document early on in your history before you go through a business divorce. Legal pitfall number 2 is this IP protection area. We have so many companies who say, hey, I've been working with this consultant. He or she is refusing to assign whatever intellectual property, whether it's code, whether it is a fancy trademark that's been developed as part of a branding product. They're refusing to assign it to the company. They're just holding ownership over it. And whether it's because of a payment dispute or whether it's because of some other issue that has come up from working with somebody developing intellectual property on behalf of the company, it is a lot harder to, again, enforce any intellectual property rights that you have without having an agreement in place that says this intellectual property has been developed under a work-for-hire arrangement, meaning this consultant has developed the intellectual property on behalf of the company and has agreed to assign it to the company after it's been developed. And so having those IP provisions reviewed by somebody who has the expertise to say, yeah, this IP protection is really important. We want to make sure the company owns what it thinks it does, is key to having the assets that the company really thinks it does, right? All of those intangible intellectual property items or assets that the company owns are only as valuable as they are protected. So make sure that protection is in place early on. Legal pitfall number 3 is we have a lot of early stage companies that make the mistake of having founders or early employees of the company do things in their individual capacity as opposed to the capacity of acting on behalf of the entity. And what do I mean by that? A common example is that we'll have companies who think they own their domain names, but in actuality, their founders registered for the domain names in their own individual name. So the company doesn't own it. Sure, the founder, might have done it thinking that the domain name would be owned by the company, but in actuality, it's held by the individual. So making sure those bank accounts are open in the name of the entity, signing contracts with the entity's name. Any intellectual property needs to be registered in the name of the company, not an individual. Those sorts of simple things where you're signing on behalf of the entity in your official capacity are really important. Legal pitfall number 4 is equity. This is another common one that comes up for a lot of early stage companies. We want all issuances of securities, meaning any sort of membership interest, any sort of units, any sort of shares, to be issued in compliance with securities laws. The SEC has a right to investigate all different types of security issuances, and their authority extends to any security that's issued. And securities come in all different shapes and sizes. So work with an attorney as soon as you're thinking about issuing securities, because you want to be sure that you're complying from the get-go with securities laws, tax laws, and also making sure that you have good documents showing what the ownership interests of the individual members or shareholders or stockholders really are. Next pitfall is one that I think just applies to all aspects of startups, and that's asking for help. I think in Idaho in particular, we have such a great network of people who are always willing to help early stage companies out, or even more mature stage companies out, and say, hey, I've made this mistake in the past. Here's how I would have prevented it going forward. There are so many great networks that you can tap into who will often have good professional advice or good advisors that you can work with to save you the trouble of DIYing things that might have been seemed like a cost savings early on, but really turn out to be very expensive problems to fix in the future. My example of making the wrong tax selection, that can be really expensive to clean up and fix in the future. So having good advice early on about how to properly structure your entity and properly submit your taxes early on are very important discussions to have and very important resources to tap into. Pretty much everybody I know in the Boise business community is always going to be willing to offer you a recommendation for a good resource so that you can at least evaluate the options before you decide to DIY something. The last kind of couple of slides that I'd like to touch on before we, make some time for questions here are just raising capital. It's an area that gets really tricky, but it's a great area to kind of work with good advisors on. So when you're raising capital, there are a bunch of different approaches that folks often take. So one, first and foremost, is bootstrapping, meaning that you're not going to seek outside capital from whether it's a third party, whether it's an individual who wants to invest in the company, whether it's your friends and family, or really formal investors like private equity and venture capital. You've decided to go it yourself and to invest your own personal funds into the entity and receive, equity in exchange for that. Next up are kind of friends and family. Those are the really close friends and family of usually the founders who have decided to invest in the entity. Next level is angel investors. The angel investment sizes that I've been seeing have been going way, way up, and it's just because there's a lot more sophisticated investors who want to invest early on in companies' history. Finally, you've got the traditional and non-traditional lenders. Those would be more like banks or private lending institutions. And then venture capital funds, which is what I work a ton with, and those are folks that are formalized to invest in what we would call like a Silicon Valley style of company, a typical Delaware C Corp, often in a space that has emerging growth companies that are looking to go beyond the next level, whether it's an IPO or an acquisition. Venture funds are motivated to invest large amounts of funding into them. And then finally, private equity, which is a more formalized, oftentimes a more substantial investment than venture capital funds, and they can take everywhere from a substantial minority ownership of the company in exchange for a large amount of cash, or can take a majority ownership in the company and help kind of run and steer the ship of the company's future. There are also alternative sources of capital. One of which being grants, foundations, state and locally, federal and state funded programs. These are programs that often have like backing from the city of Boise, or they may have backing from the state of Idaho, meaning that they may be tied to some sort of public grant program that the state is interested in sponsoring. There are also strategic partnerships, meaning that a company might partner with another company, one being more successful and willing to invest funds in exchange for a company to develop a particular line of manufacturing for them. We see that happen a lot. Those are often called joint ventures, and they're great ways to raise capital as well. This slide just gives you an example of some of the types of companies that have been really successful in raising funds. And so, as you're beginning your business venture, we wish you nothing but the best of luck and hope that you make it onto a slide like this someday in the future, or even on the list of unicorns that we all talk so much about. So I think with that, we'll kind of go to our resources page and let you know that we've got links to all of these various resources that are available in our particular area. But just encourage you to get involved with some of these organizations, or to reach out to any of us with questions about how you might get connected to the Boise community, whether it's the startup community or the small business association. There are really, really good people here who all want to see businesses thrive and survive in Idaho, and are really encouraging all of you to kind of continue your business venture and seek out the resources that we can be helpful on, and to get good guidance early on so that you can continue contributing to the state and help us all find success going forward. So let's see. That's it. So any questions? I haven't seen any come through. Craig, have you seen any?
I have not either.
Well, in that case, we'll wrap up a few minutes and hand it back over to Karen. Say thank you all so much for attending. We've had a great time presenting today, and encourage you to reach out with any questions that you may have later on. So thanks a bunch. Karen?
Thank you, Lauren and Craig. This was just wonderful information, and there will be a recorded version sent to all of the attendees today, so watch for that in your email. And we also invite you again to come to the next two sessions. Wednesday, August 12th, 11 to 12 will be cybersecurity, and Wednesday, August 19th will be employment law. So thank you for joining us, and watch for an email follow-up. Thank you.